paid jobs. You apply, you're screened, and so on. But if you're interested in something you might do, this is a job that might last all the way through August or even longer. So in a new case, $11 an hour, $14 an hour, something like that. So we also have many community events coming. We only have 2 sheets, I believe, on the back that announce the events in order, but we have a chart all over the website and Facebook. So you should be able to keep track of the coming events. The very next one is coming next Tuesday, and it is for legislative candidates of the congressional district in the Democratic race. That's next Tuesday, right? Okay, so I think we've covered everything we have to. Thank you all for coming. I'll now turn this over to Tanya Conrad, our moderator for the evening. I'll be a question reviewer along with Nancy Walker. We'll ask questions to Tanya, and she will address them to all 4 candidates. Okay, so go ahead.
Good evening. Can I just make a point? Are we guys using the projector? I think there might be a fan running on it. We can turn it off if it's not already off. Oh, is it the heat? The projector was on sometimes. Okay, well, welcome. Thank you for attending the League's Athens County Common Pleas Court Probate and Juvenile Judges Candidates Forum. Tonight we have 4 candidates, 2 that are vying for the Republican nomination, Scott Rowe and Ken Ryan, and 2 candidates that are vying for the Democratic Party's nomination, Zach Saunders and Rusty Rittenhouse. In Ohio, we have partisan primaries, which means if you get a Republican ballot, Scott and Ken will be on your ballot. If you pick a Democratic ballot for the primaries on March 17th, or if you early vote, you'll be voting for either Zach or Rusty. In the general election, at this point anyway, that changes. The general election is non-partisan. So when you vote in the general election, you will not have an R or a D by a candidate's name. I'm going to start by explaining the procedure we're going to use tonight. The order has already been decided ahead of time with the candidates. The form will include a 3-minute opening statement from each candidate. We will then go to our media representative for the first question. We'll then solicit questions from the audience, and that is done by the pencil and paper that you have on your seat. And then each candidate will get a 2-minute closing statement. The plan is to end by 8 o'clock. However, if we have a pile of questions, we may extend that time, and the candidates have agreed to that. Candidates will have a minute and a half to answer each question. There will be no rebuttals. Our timekeeper is in the first row. She will be indicating when a candidate has 30 seconds left, 15 seconds left, and then the sign to stop. I guarantee you, if the time to stop goes up, all of us will make sure it stops. Candidates are invited to share their qualifications, their experience, and talk about their plans and proposals. Candidates have been asked to focus on topics relevant to the position and to the stated questions, and they've been asked to avoid personal attacks. If they go outside of these guidelines, I may stop them to remind of those guidelines. about their knowledge, judicial philosophy, effectiveness, character, and experience. If you need another piece of paper, raise your hand, and we have folks in the back that will come bring you another piece of paper. Same thing goes if you have a question that you have completed and you want them to come pick it up to be submitted to our reviewers. We'll use as many questions as we can. Sometimes we combine questions, but our goal is obviously to get as much information to you that we see. All right. With that, let's begin with our opening statements. The first person to go will be Zach Saunders.
Thank you. Before I begin, I would like to thank the Athens County League of Women Voters for putting on this candidate forum. Your dedication and commitment to the community goes unmatched. My name is Zach Saunders. I am seeking the Democratic nomination for the Athens County Juvenile Probate Judge. I'm a graduate of Ohio University, and I can tell you that I absolutely love this county. I used to live in the city of Athens with my wife. However, our family grew to be too big, so I currently live in the Plains with my wife, who's here in the crowd, and my 2 children, who mean the absolute world to me. They make me a better person. My background goes unrivaled as a juvenile probate judge. I would say my legal background is very diverse. It helps me handle unique situations. I'm currently an assistant prosecutor with the Athens County Prosecutor's Office. Prior to that, I was a criminal defense attorney in Licking and Fairfield County, where I represented about 90% of my time with indigent defendants. That meaning individuals that didn't have money to pay for an attorney. I met fantastic people in the worst situations. It made me grow as an attorney and also understand those problems that ordinary people don't see every day. While I was there, I was also involved in juvenile court, which I was also a trained guardian ad litem. I handled abuse, neglect, dependencies when I represented children and families. My criminal background and representation goes from murders to traffic tickets. I would say that goes unmatched as a candidate. It was a great time there. Unfortunately, we were living in Athens and I was driving that way, and that was before the bypass was built. So I was getting home at 9 o'clock at night, leaving at 5:30 in the morning, and we really wanted to make our family bigger. So I was able to get a job with Malika Gall, Sloan & Sillery, which is the biggest law firm in Athens. Very well respected. Andy Malika, Jerry Malika, Steve Sloan, Bob and Sherry Gall. But ultimately, my mentor, who's a fantastic human being, is Jim Sillery. He taught me not only to be ethical, but compassionate. And it didn't matter who the litigant was or the person was, you treat them with compassion. And that has stuck with me. But I also expanded my practice, where I still practice with juvenile and criminal law, but I have civil law. I was involved in domestic relations, child support, child custody, probate, where I help several families in estate planning, but also complex litigation with Jim Sillery and Steve Sloan. Is that 30 seconds left? Thank you. Currently, I'm with the Athens County Prosecutor's Office, where I handle a litany of things. I'm the civil prosecutor. I handle grand jury, but also I handle child abuse cases, in which that is the passion that got me to become what I really wanted to be as a judge. Juvenile court takes a special person. I am that candidate. You have to hold the person accountable, but also show that you can relate to them, show them compassion, and provide them an avenue to succeed. You'll hear me more throughout this time, and I'll provide more of my qualifications and the reason why I should be juvenile court judge. Thank you.
Thank you, Zach. Rusty?
Thank you. My name is Rusty Rittenhouse. I see so many familiar faces in the audience today, so thank you all for taking the time to be here tonight. I'm running for judge out of a sense of civic duty. I believe that when you go to juvenile probate court, it could be the most important day of your life. And when you are there, you deserve to have the best qualified judge hearing your case. I'm that best qualified candidate. I'm going to give you 3 reasons why. The first is my judicial experience. I believe I'm the only candidate that has any judicial experience. For the last 4 years, I've been the acting judge for the Athens Municipal Court. This experience has taught me to think in a different manner than how I did as an attorney. As judge, I've presided over thousands of cases, and this has given me substantial background to proceed forward with a full-time position in the judicial branch. Second point is my legal experience. I've been practicing law in Athens County for about 15 years, nearly 15 years. I'm I'm licensed in both state and federal court, and I've practiced in over 25 counties. But primarily, I'm focused working in Athens. I've had a broad practice, but one of which has entailed probate. I handle a lot of probate cases. I work with clients to avoid probate. I was trained by former Judge William Lavelle at my firm on how best to handle probate matters. My third point is my life experience. I was fortunate enough to grow up here in Athens County. When I was about 2 years old, my parents got divorced, and thereafter I was raised by a single-parent teacher here in Athens. It wasn't an easy experience at times, but I was fortunate enough to have so many wonderful people in this community who helped me through, gave me guidance. Relationships, I think, is the most important things that kids can have. Since then, I've felt a dedication to our community. I've tried to give back as much as I could, especially as relating to children. For the last 4 years, I've served on the school board. Prior to that, I spent 10 years on the board of directors for Big Brothers Big Sisters, and I spent 20 years, much of which working in this very building, teaching martial arts to children. Beyond that, I have 2 children of my own, and you may have actually seen me perform as a magician. Go out and do that for kids as well. It's important to me that children are taken care of in our community, and that's why juvenile court, I think, is right in the place for me.
Thank you, Rusty. And as a reminder to our candidates, without a microphone, please try to keep your voice up as much as possible. If there's anyone in the back, we have seats available in the front. This would be a good time to move if anyone is having issues here. Please feel free to move up. Okay, with that, Ken.
Okay. I'd like to thank the League of Women Voters for hosting this event, welcome my colleagues and all of you for your participation. Thank you very much. I'm extremely honored to be a candidate for the probate juvenile judge. The honor is bittersweet, though. This election is a consequence of Judge Stewart's tenure as our current probate and juvenile judge coming to a close. It's been my privilege to know Judge Stewart and to practice in his courtroom. I've learned a great deal from him in the hundreds of hours that I've spent in probate and juvenile court during my career. I've been appointed by Judge Stewart to represent more than 100 children in child abuse, neglect, dependency cases, and in cases of delinquency. I've worked in that capacity with foster parents, with kinship homes, caseworkers, residential care providers, group homes throughout the state, guardian ad litems, therapists, as well as school officials and community control officers for children. Before I went to law school, I was a teacher at the Trimble Local School District. I was a teacher there for 12 years. I had hundreds of students that went through my classroom. I taught ages 10 through 18 in both compulsory education and extracurricular education. I have more than 11,000 hours in classroom experience with students and children. I've also been appointed in over 600 mental health cases at our local mental health hospital, Appalachian Behavioral Health. I represent individuals facing commitment to that facility and also facing forced medication. I was just there this morning and had 4 cases down at the hospital. I worked with psychiatrists, nurses, and social workers for the benefit of those individuals. My concern in mental health stems from my personal experience. I'm one of 6 sons, and my mother and one of my brothers, Paul, both had very serious mental health issues. My mother had bipolar disorder and was hospitalized from early childhood throughout my adult life until her death. My brother Paul had schizophrenia, very serious, times of homelessness for him, multiple hospitalizations, times where we tried to take him into our home but found it just too difficult. So I know how difficult that is, and for those of you that deal with that. I've served as guardian for more than a dozen people. I'm currently a guardian for 8 individuals with a varying array of mental, physical, and emotional impairment. I've worked with care providers, with Job and Family Services and Medicaid. I've worked with Athens County Board of Developmental Disabilities to provide services for these individuals. I've been on the Board of Elections, Coolville Village Council, the Athens Foundation, Citizens Review Panel, and the Rising Suns Charitable Pharmacy. Thank you for your consideration.
Thank you, Ken. And Scott.
Well, I can tell I'm not going to make the 3 minutes. So a little background about me. I was born in 1962 at Duke Law School. I wasn't attending, but my father was, and they returned, he and my mother returned back here in about 1963 and practiced for about 30 years. 32 years when he became juvenile and probate judge in 1994. I enjoyed watching him practice. I enjoyed the difficulty that it posed, and I enjoyed following him into practice too after I graduated from law school in 1989 and returned here. I wanted to note a couple things about my background. I went to Athens High School where I did a few things. I played football. I didn't win a Heisman Trophy. And I ran track. And I also acted in a play, Fiddler on the Roof, where I had one line, Mazel tov, Abba. And that was as much as my teacher could get out of me. So I married my wife married me, in 1985. We met in 1985 and married in 1986, and we've had together, she did to give attribution, the great work, 10 children, of whom 2 remain in high school, 2 are in the military. 1 is a lawyer. 1 worked for a Supreme Court justice until just last year when she moved to Michigan. 1 teaches as an intervention specialist at Miller High School. And 2 are in college playing soccer and studying hard, I hope. And 1 creates creative costumes for a theater company. So I've enjoyed coaching rec basketball and soccer for about 20 years, and also coaching the Ohio High School mock trial program for about 16 years. I was glad to have received from Ohio Center for Law-Related Education the Mock Trial Coaching Excellence Award in 2017. I guess the sum total of that is I've really enjoyed being with children. I've enjoyed encouraging them. I've enjoyed listening to them and helping them along if I can in some way. And that experience has most certainly given me the gray hair which you see right now. So I've enjoyed serving, among other things, in some community things. The Good Works Board, I was Judge Lavelle's appointee to the Children's Services Board in 1992, the Ohio State Bar Association, and let me skip to this and get to the rest later. I declared as a candidate because of those years of experience led me to think I need to serve my county. And I believe it's ultimately the duty of a judge to listen, and I'm dedicated to doing that.
Thank you. We're going to move to our question portion. Again, if you have a question that's ready, please just hold it up at any point, and our question collectors will come and pick it up. We're going to move to the media for the first question. This is, hold on, Caitlin Thorne with the Athens Messenger, the new editor, who was introduced earlier. Your question.
All right. The position you are all seeking has the potential to have a deep, profound effect on the young people that come through the court system. What do you believe is the most important aspect of the position?
Start with that.
The most important is to give them hope. It's a little bit different, this judgeship, than ordinary judgeships, is that juvenile court is to rehabilitate the offender. I have plans to make them succeed, or plans that I would like to implement to make them succeed. Obviously, we live in an impoverished county where there's not a lot of structure, there's not a lot of opportunity, and if those individuals are in my court, what I want to do is build that structure, give them that hope. What I've noticed through my time as a prosecutor and also as a defense attorney in juvenile court, which I believe I'm the only candidate that has that experience, is that I've noticed that there's a lot of underlying mental health issues that aren't addressed. I see these individuals graduate essentially to adult court, and the big aspect is that there's mental health left untreated. What I'd really like to incorporate to give them that hope is to have some structure. I would like to have a mental health counselor or a mental health probation officer involved in the court, which we can address the mental health concerns with the parent, but also with the child, and collaborate with them to try to make them succeed. Again, ultimately it's giving them hope, and that's what I hope to do. Thank you.
Rusty?
The question again was, what's the most important aspect of being juvenile court judge? Okay, I think it's to provide rehabilitation rather than retribution. I believe that that's the goal of the juvenile court, is to rehabilitate the offender. I intend to take a trauma-informed approach to being juvenile court judge. I believe a lot of what children experience when they end up in juvenile court as a result of something that they experienced earlier in their life. Some trauma often could be physical abuse, sexual abuse, witnessing something that happened before. And the first step to treating that is to recognize that the trauma occurred. From there, it's not a simple process of just counseling or saying or being disciplined. It's, I think, a multiple step approach, and it's going to take almost a community involvement to do it. I think the only way you'll ever break the cycle of children coming back to juvenile court is finding them a way to form healthy relationships in the community. Going home to a bad environment, it's just going to end up them ending back there. So as juvenile court judge, I would try to find a way to foster those healthy relationships.
Thank you. I think there's absolutely no question that the most important thing when you're dealing with children and helping them to get to see where they can be is to know where they are and know the vision for them. Have a vision for the child. You have to know where they are. So many of the children that I taught had no vision. They had none of it in their home life. They saw none of it or very little of it in their community, even though many people in the community had great vision. But they would sell themselves short all the time. And you had to show them where they could go and who they could be. And to do that, you had to know where they were. Any successful teacher knows that you've got to start with the child where the child is to take them to the next step. And that's an essential part of this. You're correct, Ms. Thorne. Your insight in the question is very accurate, because the probate juvenile judge is in a very unique position to make decisions that significantly impact a child or a disabled adult or anybody who's impaired or vulnerable. That's who you're seeing. We have the tools and the discretion to be able to do it. It's really, really important that you have the background and the knowledge to fall back and to be able to see that vision and help your child see that vision for his or herself.
So as I ended, before my 3 minutes were up, I think the key thing is to listen. The key aspect of a judge with discretion is to listen. First, to listen to the law, to understand what's the mission that the law is giving. And those are different in probate court and juvenile court. So juvenile court involves a really intense interaction with children. And it does require in the judge a lot of experience to be able to discern the child. And one of the things about discerning is first listening. And that listening requires, I'd say, a really heightened and intense kind of listening where you're seeking to perceive the purpose and the gifts of the child and the problem at issue. The juvenile court can't solve every issue, but it certainly can intervene in things. I remember that happened to me as I was not in juvenile court, but I remember the experience in high school where people intervened in my life and made quite a difference. In probate court, it is different. Probate court generally involves, other than guardianships and incompetency adjudications. It involves the administration of the law of property, of business, and my time is up.
Thank you. We're going to move to audience questions now. Thank you, Caitlin. The first question, and this we'll start with Ken for this. What strategies might you employ to reduce the trauma of the court experience for children and their families?
Well, thankfully right now, children who are going through abuse, neglect, and dependency cases rarely have any actual courtroom experience. The only time they actually have any kind of courtroom experience is where we have an in-camera interview. Those generally happen, and I would certainly continue in this model to have those happen with other individuals that the child trusts, and be sure that I know and understand the capacities of that child to appreciate that meeting, and to rely upon the guardian ad litem appointed in the case, to rely upon caseworkers, and to get feedback from whoever their care providers are, whether it's foster parents. I think foster parents are just far too often left out of cases. I understand the law doesn't allow them to have standing in a case, but I think their experience is invaluable, and to know and understand what those children can do. So thankfully, they have very little actual courtroom experience when it's abuse, neglect, dependency. But if it's delinquency, now granted, in those cases, you're generally dealing with an older child, like the 10 to 18-year-olds that I taught. I'm sorry, if you don't do something wrong, I think a child needs to be there and be present for what they did wrong. Understanding sometimes it's not always the child's direct fault in that. I understand how it is. Thank you.
Thank you, Scott.
Could you repeat the question?
I sure can. What strategies might you employ to reduce the trauma of the court experience for children and families?
Well, as I said before, it's really important for a child when I'm in a teaching relationship, it's important for the child to know that I care and that I really am aiming for their uplifting, no matter where they are. It's important that they know, therefore, that I am listening to them. So one of the things to do is to perceive the support network that the child actually has. And that could be a broader question than simply what's the allegation against the child or against an adult. To perceive the actual support network that's working, and then to work to solidify that and to let that support network work. And that will always mean sorting through a lot of evidence and sorting through a lot of different relationships. Then to seek to fix what is actually in disrepair. Something's in disrepair, it's made it to juvenile court, and then just to seek to fix that. There are a lot of things that when once fixed, they can come back together themselves. It depends upon the particular situation. Some are more drastic than others. But not rushing in to disturb that which is already working is really an important key. As I think if we each thought to our own circumstances, we would realize.
Thank you. Rusty?
Could you repeat the question one more time?
I sure can. What strategies might you employ to reduce the trauma of the court experience for children and their families?
Okay. Well, first, I disagree with the premise of the question. I don't think it's the court experience that's the trauma. I think it's the trauma that brought the kids to the court experience. And that, again, is something that I think you need to address off the bat. With a trauma-informed approach, there's a simple test that you can give to find out if the child has experienced some trauma. Once you've identified that trauma, you can then seek to find the best manner to address it. And it's not going to be a one-stop shop. My favorite answer as a lawyer, it depends. Each case is going to be different. And juvenile court isn't a one-stop shop. You can have kids in there for various reasons. It's not necessarily because the kids were unruly or delinquent. It could be for a number of various situations. So again, the first thing I would do does not accept that the court is the place where the trauma occurs. I believe that it's the place where you identify the trauma that has occurred.
Thank you. A big part of juvenile court that I think really hasn't been discussed are child custody cases. Child custody cases involving parents that have children out of wedlock. And when I was in private practice, particularly with Malika Gosselin and Ancillary, this was a big part of my practice. And unfortunately, I saw the absolute worst in parents. They would essentially use their child as a pawn to hurt the other parent. And ultimately, that went back, and I met a lot of these kids. It hurt that kid. I want to be deeply involved in those cases. I know that Judge Stewart currently doesn't have a very much hands-on approach. I know that Magistrate, I believe Featheroff handles it right now, but I'm going to have a very big approach to this, is that I'm going to be involved in those hearings. I'm going to have that frank discussion with the parents, starting off is that the child is what is important here. What's in the best interest of the child? Another part that I think we need to take a look at is that I'm going to discharge my duties with skill, heart, and my conscience. A lot of the abuse, neglect, dependency cases, we need to focus on the reunification. And with that, there's a collaborative evaluation that I want to take care of and also provide treatment services, not only substance abuse to the parents, but also some of these kids that have focused on that trauma, is that we directly hit and work as a team. And I think that that will be a big part of my judgeship if I'm elected. Thank you.
Thank you. Question number 3. As judge, you will make decisions about abused children. Do they return home? Do they become available for adoption? You do not have a crystal ball. How prepared are you to make these difficult decisions?
I'm very prepared. A lot of us have happy memories of sitting at home in the kitchen with your family. I don't. When I was a child, my memories of sitting at home, my father would make me sit in my underwear at the kitchen table when I was 3 or 4 years old. And it was in part to humiliate me, but it was also, when he went to hit me, it made it easier for him to strike my skin. I've been abused. I know what the kids have gone through, and I can relate, and for that reason, I will take this very seriously, using my own experiences in handling those situations.
Thank you. I briefly stated in my opening statement that my true passion, what got me started in wanting this job, was that I handled child abuse cases. Along with Elizabeth Hepper, who's in the crowd tonight, I've handled several juvenile or child abuse cases. The one that really got me started was in 2015, we had a prosecution involving 2 adults that abused a 3-month-old child, which had 25 broken bones, a complex skull fracture, a brain bleed, a torn frenulum. She was paralyzed on one side of her body, legally blind. I will tell you that I have been a majority of my career fighting for those individuals that are vulnerable and really have no voice, the elderly and obviously juveniles here. I've handled several of those cases. I've had to be involved with abuse, neglect, dependency cases, listen to those transcripts, and prepare myself for this. It's hard, it's difficult, but it's something that I truly have a passion to do. With that story, there's ultimately something good that can come out of this. I was able to see that 3-month-old progress until, I think by the time the case was done, she was about 4 years old. She was adopted by her parents. I was invited to that adoption, and while everybody was celebrating the adoption, I chose to be with that child and play Ring Around the Rosie. Children are my passion. I will tell you that these are the most serious cases we have, and this is something that I promise you will be at the forefront of my tenure. Thank you.
Well, so abused children, am I prepared to make these decisions? My first thought is it's kind of like having children. After having 10, I think I'm pretty convinced that no, I'm not prepared to have children. And the reason is because it's a monumental task to do it well. And So everybody who has parents in here, who has children, realizes that. We all have successful children, and to some degree, we have children whom we still want to encourage with success. I would say this, that you don't go in with the assumption that you're prepared so much as you just realize how you have to use the experiences that you have been provided in order to have a residuum of knowledge and understanding, a commitment to listen to the situation and to make the best decision that the law allows you to make, and especially aiming for a just result. And I think what that means is really aiming as a purpose, aiming for peace in that child's life, so that that child can go from there and build a life that is a productive and joyful life. I enjoy teaching mock trial students, some of whom are not very far along when they come, and just doing something to inspire them that they can achieve great things.
Thank you. I think I would absolutely be prepared for that scenario. When you talk about abused children, there's no doubt that those children have to find stability and find their forever family. When you're talking about abused children, I would have to say those are probably going to be the easier cases. It's cases of neglect. In cases of dependency, we say way more cases of dependency because of drug use. Parents didn't abuse the child, they just can't quit the drugs. And then they'll show, okay, well, I can. Now I'm good, I'm ready, can I have my child back? That's when you want the crystal ball. When your child has got broken bones, when your child has detached retinas, like I said, I've represented over 100 children in abuse, neglect, and dependency cases. I will not tell you the scenarios of abuse that I've heard. You do not want those images to carry home with you tonight because they won't leave you. Abuse, no problem. We'll find you your forever family. We can do that. We can give you a new hope because it's about the child in this case. It's juvenile court. It's not parent court. But boy, is it going to be tough. And I've seen it, and it is tough when you have well-meaning parents that just can't parent, either through mental health or substance abuse or what have you.
Thank you. The fourth question, we'll start with Scott. The question is, what role should religious beliefs, and specifically your own religious beliefs, play in the discharge of your judicial duties?
So I think it's important to recognize everyone comes to every situation, every question, every answer with some sort of presuppositions. And probably one of the great maturities, one of the great maturing kinds of inquiries is to examine what those are. I tell my students whom I teach, both the OU finance students that I teach each fall, and I teach my mock trial students, always become aware of your presuppositions, and it will open up a world of understanding to you. So everyone comes with those, identify what those are. As a judge, you have to be committed strictly to applying the law. Whatever the law is, you apply that law. I think probably everybody would, I hope everybody would have as one of your presuppositions, or one of my presuppositions, that we treat people justly, we treat people honestly, we treat people with kindness, but those are all things that the law really requires. And of a juvenile and probate judge, there are many opportunities to deal with people in those kind of ways. And it turns out to be really important. I've had cases with each of these men and many other attorneys, and when we end up resolving the case resolved in the fashion of kindness is really the best case resolved.
Thank you. Ken?
Thank you. I think religious belief would inform my discharge of duty in probably 4 ways. One, if I was elected judge, I would have to take an oath of office. I've taken oaths. I've taken an oath when I became an attorney, and I took an oath when I was on the Board of Elections. And I've taken oaths when I'm swearing affidavits and things of that nature through my practice. I would take that oath very, very seriously. It would mean the world to me, and to be bound to the duty for the oath that I have sworn. I would also believe I have a moral obligation to work diligently. I think it's important to be diligent in your practice, and I think we have a moral obligation to be diligent with our talents and our gifts. I think it would inform my practice and the discharge of my duty to be honest. I would definitely strive in every way to be an honest judge and to treat everybody honestly. And I think we have a moral obligation to obey the law, and that is absolutely what I would do.
Zach?
I don't think it's been said, but religious beliefs will not be affected in my decisions. Like Kenneth said, we're here to uphold the law. We take an oath of office. The main thing that we need to be is fair and impartial, considerate, honest. We're here to protect people. We're here to make sure the juveniles are protected. We're here to make sure that the elderly are protected. But ultimately, my concern is the welfare of the children when I'm dealing with juvenile court, and to provide closure to individuals when we have estates. Just in short, religious beliefs will play no role as a judge for Athens County Juvenile Probate Court. Thank you.
Can you repeat the question?
What role should religious beliefs, and specifically your own religious beliefs, play in the discharge of your judicial duties?
None.
There's a time saver, right? All right. Question 5, and we'll start with Zach. What steps would you take to make the court more accessible for unrepresented litigants?
That's a great question. Currently, I sit on the Athens County Law Library Board, in which there are several forms that indigent individuals can hand out, but I will treat and have treated, because I've been on that side where I'm representing a person. It could be a child custody case, it could be a domestic relations case, and the other side is unrepresented. I can tell you, and if you would ever meet one of those people, that I treated them the same respect as I treated an attorney. In my courtroom, it doesn't matter if you have $100 million or if you have nothing in your bank account. You are going to be treated fairly. You are going to be treated the same as everybody else. But I will provide avenues. I will make them aware of the forms that are filled out. I know that there's a poverty law clinic. I will make sure that the court has flyers. Also makes them aware that there is a poverty law clinic in which local attorneys that I've actually been a part of to help out, to provide them some guidance, because I know that we do live in an area that is impoverished, but I think we need to provide them avenues to be appropriately represented if they can't afford, obviously, an attorney, but to gain some knowledge, and I think that's a good way to do that. Thank you.
I would do it the same way I've done things the last few years. I would advocate for education. I think helping individuals in the community know where to go for resources would be the best step. And so you would try to provide as many outlets for education as to where you go to learn to fill out the form, where you go to find help, if it's a poverty clinic, what the date and time of those would be, the phone numbers, the emails. So I would do that through education.
Thank you. I think it's important to distinguish which cases where this would really be implicated. When it comes to abuse, neglect, and dependency cases, parents that are facing the loss of the rights to parent their child, which is a fundamental right, are afforded counsel. So unless they simply did not want counsel, they would be afforded counsel. That is the current practice at this point. Children who have been alleged abused would be afforded counsel. That's where my role has been during the 12 years of my career in representing those children. I think also when you're looking at juvenile delinquency unruly cases, again, those children are afforded counsel and have that opportunity to have counsel. Where you really need counsel and where you see most of your pro se litigants going through probate and juvenile court is either in their own custody matters, but really primarily where they get themselves into trouble is in guardianship proceedings and in estate proceedings. There are opportunities to continue to keep people who are pro se litigants informed, up to date, with frequent notices to them so they understand their duties. If you are a guardian, you're required to take guardianship training courses. I would like to see that available within either our courthouse or some other public facility where people could go to get that training so that they would know and understand the duties of a guardianship, because that's very often where they find themselves in trouble.
Could you repeat the question?
Sure. What steps would you take to make the court more accessible for unrepresented litigants?
So at the intake level, as the case just initially comes in, some kind of an assessment is made, and some kind of assessment is made to provide counsel to litigants in certain cases. It's not every case. I think there's a financial burden that the county would have to undertake, and also the state would have to undertake. I actually serve on the Government Affairs Committee of the Ohio State Bar Association Board of Governors, and we have recently, just last few meetings, discussed that very point of where we would find the money to expand the kind of representation that is necessary for people who are indigent. I also am very in favor of establishing appropriate kinds of educational programs. I remember years ago talking with Karen Harvey about that, and there are some things available at Children's Services. I think it would be a wonderful idea for, when my father was the probate judge, we had the guardian ad litem program going on, which has been extremely successful, and that's something for all of you as you see a child or litigant who needs to be inspired to just get involved with someone and provide the kind of successful interaction with them that they probably are missing. Sorry, I went over.
Thank you, Scott. And actually, that's a nice segue to our next question, which we'll start with Ken. The author of the question says, in the CASA program, I'm interested in how you see your relationship with Children's Services, whose mandate is to reunite kids with their families, even when it's not in the child's best interests. I'm very curious as to whether the juvenile court judge, whether you if you were to become judge, feel obligated to agree with Children's Services.
The relationship would be one simply as another party. That is what the law says they are. That is the role that they play in that action. To answer the last part of the question, absolutely not. I've been in cases where I've seen and I understand Children's Services has particular mandate and has to follow certain things they're obligated by law. That is why this is such an important position. The juvenile court judge has discretion to always and should always act in the child's best interest. The law provides them that discretion. Being able to reflect upon your understanding, your experience, being able to listen to guardian ad litems, caseworkers, teachers, therapists, medical providers, all these people that are working for the children, it's essential that you listen to them, you understand what's happening, and you recognize that Children's Services despite all the hard work and the unenviable position that many of those caseworkers are in, and they have to follow their mandates as well, to know that they are a party. They're going to make their recommendations according to the dictates of in the discharge of their office, but it would be my job, first and foremost, as a juvenile judge, not Athens County Children's Services judge, to act in the child's best interest.
Thank you. Scott.
So I remember I mentioned in 1992, Judge Lavelle appointed me as I was a pretty young attorney, but he appointed me as his appointee on the Children's Services Board. And I remember his charge to me was, don't go along with everything you hear. So I did my best as a young attorney to do that. And I recognize this out of that experience, that Children's Services does have a charge. It's a critical charge. They're sometimes the only agency available to intercede between something wrong that's going on and something and the solution. But they're not automatically right. They have a burden of proof that they have to meet. And it's the judge's responsibility to make sure that that burden of proof is met. And so that gets to the actually cost of the guardian ad litem program. I think the experience is that really for the judge, those CASA volunteers are sometimes the most normal thing, maybe the best quality of analysis that the judge will ever hear in the case. And so to be able to rely upon people of real substance, of real accomplishment, volunteering to come into the situation is and can be invaluable. And so kudos to everybody who volunteers.
Thank you. Rusty?
When I was younger, I was on the board of directors for CASA. I appreciate the question, and I've also served as a guardian ad litem. But as a judge, I would consider each case on a case-by-case basis. I appreciate the information that they provide and the service they provide, but ultimately what I'm going to decide is what's in the best interest of the child.
And Rusty, you'll be first up to answer the next question.
Are you going to skip? Can I go?
Oh gosh, I'm so sorry.
That's okay. No, thank you.
Are you neglected?
I feel a little neglected right now. To the CASA volunteer that submitted a question, thank you for what you do. I also was a certified guardian ad litem. I know how tough it is and how diligent it is to keep on top of things and to provide your overall report to the court. Going last, I'm echoing what they say, but Children's Services is a party. The court is not representing juvenile court or Children's Services or their interests. We're focused on what is the best interest of that child, and each case is a case-by-case basis. It's a complex matter. What you need to understand is I'm going to be looking to separate children only when I absolutely have to, when it's necessary for that child's welfare, and when it's in the interest of public safety. I'm going to take each case under severe consideration. I've handled those child abuse cases. Unfortunately, I've had to close some of those cases because I couldn't meet the burden. Those are difficult matters, but ultimately that's something I'm really up for the job, and thank you.
Thank you, Zach.
Thank you.
Question 7, we will start with Rusty. And this is a two-parter, so get your pens ready. What has been the most meaningful pro bono experience you've had? And what do you believe the role of an elected judge is in encouraging volunteer activity by lawyers? So most meaningful pro bono, and what is your role as judge in encouraging lawyers to undertake volunteer activities?
Okay. Well, gosh, I've been in private practice a long time, and a lot of people haven't paid me to do that kind of pro bono. No, I've spent a lot of time working in the poverty clinics and met a number of kind people facing dilemmas. And I don't know if I could pick one individual. I've enjoyed working every one of them. I would encourage other attorneys as judge to do pro bono, as it helps, especially young attorneys, get further experience in different cases they probably wouldn't get otherwise. It also plays an important role in the community by providing an attorney. As a judge, I have people come before me all the time representing themselves, and rarely does it go well. So lawyers play an important role, and people are best served if they have an attorney there. I understand the financial burden, and so to help bridge that gap, I would encourage attorneys to do pro bono work.
Thank you. I've been in the poverty law clinic several times, provided advice, but one that really sticks out, and besides family friends, I'm assuming don't count for family as pro bono. Okay, because there's been a lot of that. But ultimately, there's one in particular. There is a woman who's near and dear to my heart, suffered an injury, was still working, had to go through Social Security, and didn't really know what to do. And she's like, Zach, will you go along with me? So I took the time out of my day, I think we were there for 3 hours. And I just loved, because she just asked me all sorts of questions, but ultimately, she just needed someone to rely upon, and I felt that I was doing a service to the community, but also to her. Role of elected judge to try to get attorneys involved. I've been a past Secretary of Treasurer, Vice President, and President of the Athens County Bar Association, which is elected by the peers of the legal community. Getting people involved through that sets up pro bono. I advocated as president to get more people involved in the poverty law clinic. I try to serve, my wife and I are both attorneys. Whatever we can do to help people, it doesn't matter coaching sports or sitting on boards, law library board, but ultimately giving back to the community is what we should be doing as attorneys. Thank you.
Scott.
I was thinking here the most meaningful pro bono. Sometimes pro bono happens sort of by accident. That is, it just turns out you take a representation and someone can't pay. So what do? You just keep representing. And maybe the most meaningful one that I have, I can't tell you many details, I have to be vague because I have a duty of confidentiality. But just vaguely, it involved a wife whose husband was divorcing her, having moved here from a distant state, and they had a child who was still in middle school, and it wasn't a pretty litigation. It was really nasty, but she needed somebody, and I just couldn't turn it away, and I couldn't say no. And just recognizing that it's when a real person is in front of you with real needs, you just have to make the effort to do it. I was really glad in that case. It really turned out well. It turned out really well for the child, and it turned out well for the mother. But they're hard-fought things. They're tough.
Thank you, Scott. Ken.
Thank you. It's interesting to ask this question because, quite honestly, it's one of the reasons why I own my own practice. And while I'm a solo practice attorney, when you are an attorney with other attorneys and you have a practice together, you owe a duty to one another, to support the business, to act diligently, to promoting your business, and to further their interests as long as yours. As a solo practice attorney, which was a conscious decision of mine, I realized, and I did this because I knew I would have the opportunity to offer pro bono or reduced cost services to people at my own discretion without having to consult with another attorney. Is it okay if we don't charge Mrs. Smith the full amount? Can I just charge her $100 or $50 or nothing? I've volunteered at our poverty clinic many times. I've done a number of civil protection orders pro bono for people who have been assaulted and need protection from their assailant. But the one it's hard to remember because when they're good, you're happy it happened and you let it go and you move on. The hard ones are the ones that really stick with you. But one time I helped an overseas service member. He was stationed in Germany, got married over there, and then his wife took off, gone. And so we had to help him process his divorce here in Athens County, because he was still considered an Athens County resident while he was sitting in Germany. And I cut him loose, and I think he learned his lesson, because I hadn't heard back from him other than good things.
Thank you, Ken. Question 8, and we'll start with you, Scott. In juvenile court, what cases would you hear yourself, and what would you assign to a magistrate?
So as a judge, I have really appreciated I'm not as a judge. As a lawyer, I've really appreciated every time I get to be in front of the most seasoned judge, the most seasoned person. The more seasoning, the better. So I would really like to start out by hearing a lot of cases, and just, because of the caseload, you can't hear every case. But just picking and choosing, I would make the assumption I have a lot to learn, and that I would want to do that by diving in, really getting into the depth of the water and hearing people. I really think after 30 years of practice that what I said earlier about listening is really a learned skill. It's a learned priority. It's a learned purpose. And I would make the assumption that I better spend a lot of time listening to people and learning from them. And so which cases would I hear? I think I would try to hear as many of them as I can, and still be producing the decisions that need to be decided.
Ken?
Thank you. I would certainly follow, much of our current model that Judge Stewart has adopted. I would hear every single children's services case of abuse, neglect, dependency. I would hear every guardianship case in probate court, and hear estate cases that I've prosecuted. I have been many times, and again represented many children in delinquency and unruly cases. Currently, we have a very skilled magistrate in John Perrin. I think he has the appropriate approach, tenacity, tact, and understanding of children. He's well seasoned in that, and having sat in his courtroom with him on the bench, not only there, but also him on the bench in our mental health hearings, I know he is very broad-minded and well understands those cases. In cases of very serious felonies for children, I would certainly hear those cases directly with his input. With respect to our magistrate who hears custody matters, that's a very heavy docket. I think I would be disingenuous if I told you I was going to hear every single one of those. It would be just almost impossible demand on your time to hear that docket. But I think a very close relationship with that magistrate and a close relationship with that court would be imperative and would be part of my practice.
For abuse, neglect, dependency cases, I would absolutely hear all of them. They're complex, they're sensitive, they're obviously time-consuming. For someone that works in the courthouse, in the courtroom daily, and also in juvenile court, I would likely to say that juvenile court represents the juvenile probate side. About 70 to 75% of the court's time is spent on juvenile court work. For those abuse, neglect, dependency cases, that's something, if the burden falls on a decision, it's going to fall on me. For juvenile delinquencies, I will hear all felony cases because of my vast background in criminal defense and also criminal prosecution. Most misdemeanors I will try to hear. I understand that misdemeanors, which are obviously less serious than felonies, are more likely to occur. So I won't be able to hear all of those, but what I've noticed with my time in juvenile court is right now there's a lot of kids that reoffend or have probation violations. I'm going to be the one that is going to hear those probation violations because they need to hear directly from me how they're going to be held accountable and really what the issue is, and we need to figure out what that is. Child custody cases, I'm going to tell you I would like to be involved as much as possible. Like I said earlier, is to talk with those parents and understand what is really at heart here is the best interest of the child. I know that my time is going to have to be flexible. I'm going to be working hopefully with Judge Stewart before I take the bench so I can figure out how to best exercise my time. But thank you.
And when I serve as acting judge at the municipal court, I hear the entire day's docket, everything from the arraignments, pre-trials, trials, civil matters, you name it, that I'm the only one there to hear it that day. I would love it in juvenile court and probate court if I could take the same approach, but that's just not realistic. Currently, we are very lucky in our community to have Magistrate Perrin, who handles a lot of the lower level juvenile matters, here's the arraignments, and he does a great job at it. And I also suspect that the system as it's set up now is done so for a very important reason, and that may have to do with the right to an immediate appeal when you hear certain cases. So before I commit to this, I would want to learn more from Magistrate Perrin, Judge Stewart, to find out the reasoning for the current setup, and I suspect I would keep the same setup because of the logic behind it.
Thank you. Question 9, we'll begin with Zach. What changes, if any, do you plan to make to the current court?
That's a great question. I have tremendous respect for Judge Stewart to start with, and there's not a lot of drastic changes that I'm going to make. One that I really would like to take into consideration is there's a big issue with truancy. I would like to create a system where there are school liaisons in the court system, either a probation officer or someone related to juvenile court, where we can discuss those issues of truancy with particular individuals, children, with the court or with the school, and figure out what those true issues are, try to build some structure, build some collaboration there. But also, I'm going to involve that a little bit step further, is I'm going to try to get involved with elementary school students. Because ultimately, I want the kids to love school. And a big part of that is to speak with them, speak with their teachers, show them that school is important, that they love school, but also the repercussions of if they do not go to school, you have those truancy issues. I also spoke about mental health. A big avenue that I would like to take is the focus on mental health. Again, I want to get a mental health professional in the court system. I know that some of these individuals are seeing guidance counselors, which ultimately is great, but once that school year stops, my concern is what are we going to do about the kid then? Additionally, we do work with Hopewell, but that forces the kid to then go to Hopewell. If I can have it in the court, we can nail everything together and try to focus what really matters is the kid.
Thank you, Zach. Rusty?
Can you repeat the question?
Sure. What changes, if any, do you plan to make to the court?
All right. The last several weeks I've been going around speaking to various individuals that are stakeholders and have roles within the court system to find out how things are going and what they view as needing improvement. For the most part, I've been getting very positive feedback. The areas that they've pointed out to is an improvement in communication. Communicating to schools and other individuals as to the date and time of hearing so that they can get there without being notified the last minute. So I do think that's a very important aspect that I'm going to work to improve on. Another that I've found frustrating in my own practice is ex parte orders. I would try to do away with some exceptions with ex parte orders. And those of you who don't know what an ex parte order is, it's an order that's issued to one party without the other side being notified or giving an opportunity to weigh in on the decision. They do play an important role, for example, in protection orders at times when it's an immediate need to protect someone from harm. But in a lot of probate matters, I see them come through, and often they have to be overturned down the road. And that's a waste of time.
Thank you. Ken?
Thank you. Again, I think our current system in our court has a lot of the tools, a lot of the mechanisms available that do the best job possible to help children who are in difficult situations. You know, very often, and it comes as little surprise that the root problem in most every instance of a case that comes in front of you in juvenile court rarely stems directly from the child. Very often it's a problem at home. So those are very difficult. I mean, the court can only go so far into the private lives of the individuals who are impacted by the case that is before them. So I would like to see more support for our community control officers and truancy officers so that they have an opportunity to be as active. Those are your hands, your feet on the ground, and your eyes and ears in the community. We're very fortunate to have an excellent Casa Guardian ad litem office. I would like to keep that as strong as it currently is and maintain that strength. I think when it comes to people who are acting just kind of like we said before, pro se, they need to have good notices, understanding what's happening in the court system, and have proper training and availability. I'd like to make that available to community members who are pro se so that they can do the best job discharging their duties.
Thank you, Ken. And Scott?
So the court, as it has been developed to today under Judge Jones, who I think ended his judgeship in 1990, and then Judge Lavelle, and then Judge Rowe, and then Judge Stewart is really pretty well established, and it really does work pretty well. And so other than learning initially to hear each case and becoming experienced as a judicial officer, I don't think there's anything about the current structure that I would majorly change, and that would tweak, I think, as time went on. Judge Stewart is a really well-regarded judge across the state. I was just speaking last week to a state leader in special needs law as we were preparing a motion, and it's really nice to know we have a very well-respected judge here in our county. If there's one thing I might do, it might be to add some kind of computer access, internet access to probate court records, maybe juvenile court records, but the main thing is to protect confidentiality. So I would do that only in such a way that did not threaten any kind of confidentiality records getting out. And that would really be a trick. The main item there is to protect that which is confidential and go further.
At this point, we got started a little bit late, so my plan is to ask 2 more questions and then move to closing statements. Question 10, we'll start with Ken. I work at a local high school, at a youth homeless shelter, and have a family member in a terrible home situation. I think we are all aware of the policies that push to keep children with their biological parents, except in extreme circumstances. Daily, I see the consequences of these policies. So many young people come out damaged from being kept in these situations for much too long. What are your thoughts on this?
I would agree that absolutely can occur. As the probate and juvenile judge, though it's difficult in that particular position, the role of the juvenile judge is act fairly, enforce the law, and always act in the child's best interest. We have agencies, our Athens County Children's Service agencies. We have mandatory reporting for many people and professions to be able to provide notice of any time that there is any suspected abuse of a child or neglect, and to run that through those proper channels. Unfortunately, in the judicial system, in that system, we don't see it on the ground all the time. There is supposed to be a safety net in place. I don't doubt that there are times where that safety net fails. I also understand that Children's Services has only a certain limited capacity of cases that they can hear, and it's difficult to always know ahead with any absolute certainty what situation rises to the level of one that needs to be brought to the attention of the court. I would hope that every situation that needed to be brought to the attention of the court to protect the child would come before me, so I could act on that.
Thank you. Scott?
So the overarching goal of the juvenile court is the protection in the best interests of the child. That requires someone who's in authority to be very perceptive, more than anything, to deeply care about each case, each child, each person, each parent there, and recognize, and be perceptive also to recognize when something is going awry, because not everyone tells the truth. It's requisite to ask questions, piercing questions, questions that would be in this setting very, very uncomfortable. I think the mission is also to try as best as possible to inspire the community services personnel of the huge importance of what they're doing, and where they suspect something's wrong, to keep pushing, keep pressing, because at risk is a child whose whole life is right there in kind of just a vessel. And my goal would be to encourage them to produce the kind of evidence needed. Ultimately, there's this horrible limitation, which is called the law, and the law grants rights to each person, and we have to protect the due process rights of everybody, equal protection rights. And that's a big subject. I wish I could talk more. Let's see, my time is.
Can you repeat the question?
Oh, boy. I work at a local high school at a youth homeless shelter, and I'm a family member in a terrible home situation. I think we are aware of the policies that keep children with their biological parents, except in extreme circumstances. Daily, I see the consequences of these policies. So many young people come out damaged from being kept in these situations for much too long. What are your thoughts?
It saddens me. That's fine. These situations exist. I know that it'd be nice if you could give us each a litmus test or a cookie cutter question that we could answer, but that's not how the judicial system works. As a judge, you consider each case on a situation-by-situation basis, and as judge of the juvenile court, you ultimately decide what's in the best interest of the child. And so that I would utilize those same principles in this situation and all others.
And Zach?
As I've worked at the prosecutor's office, I've seen those toxic situations. I can tell you when I was in private practice, I saw those toxic situations. But as I'm the last one that goes, my personal beliefs of what should happen are thrown out the window, and I'm supposed to apply the law and apply it fairly and impartially. I know the law is to push forward reunification, but when there is some trauma-based issue with the child out there, I think we really need to work to come together as a court and with the services that the court has to provide that treatment and evaluation, whether if it's substance abuse for the parents that needs to be addressed, but also speaking to the kid if it needs to be in camera or hearing from the guardian ad litem or hearing from children's services. Ultimately, it's what's in the best interest of the child. So the cases that I will deal with, I'll be fair and impartial, but know that I do have that background of the trauma-based issues that come up with the toxic relationships. Thank you.
Thank you, Zach. And our final question, we'll begin with Rusty. And the question is, what do you believe will be the most difficult aspect of being a juvenile court judge, and how will you manage that?
I think back on my legal career and the most difficult case I ever had. The two hardest cases, I'll say two, both involved juveniles and children. One, I represented a child that had shot his brother in a hunting accident. And I sat with him and worked through the process as he worked with the state agents to explain what had happened. It was a horrible traumatic experience that this child suffered. The other was a case I had where a child had fallen through a septic tank and drowned in a septic tank. I can't think of a harder situation for someone to pass. And to make it even worse, the mother found the child immediately thereafter and tried to save the child unsuccessfully. So cases involving extreme abuse, neglect with children will be the hardest for me to deal with. I'll be able to do it. But I think it's the same answer for anybody in this room. Whenever you hear these situations, it's hard to deal with. But that's why we're here. We all have an important role. We have to play it. We have to do what's best for the children in our community.
Thank you. Zach?
It absolutely will be the abuse, neglect, dependency cases. The good part that I would have to say with my experience is that I'm seasoned in that area. I've dealt with several traumatic and heartbreaking cases that I don't think anybody would ever want to deal with. am not ashamed to say at first, it was hard. It was extremely difficult. I would go home and I would talk to my wife and hug my children a little tighter. But ultimately, I have gained through that experience is that there's ways to shut that off and keep that at work. But ultimately, it's absolutely the abuse, neglect, dependency cases that are going to be the toughest and the most sensitive, because that's ultimately determining whether that child is going to go home with their parents or whether they may end up in foster care or hopefully later adopted if they are introduced to foster care.
Scott.
So read the question again, please.
What do you believe will be the most difficult aspect of being a juvenile court judge, and how will you manage that?
Well, anytime you're in front of two or more people and they're telling inconsistent stories, it's always difficult to have to discern, well, who's telling the truth or who's not telling the truth, who is submitting the preponderant evidence. That's always difficult, and I think it's a serious duty of a judge in every case to, and that weighs heavily. The kinds of cases that might be the most difficult, they could really go across the whole breadth of probate and juvenile court. Some are guardianship cases where the court is being asked to declare someone mentally incompetent who is maybe borderish, and those are heart-gripping cases. Also the cases where a child has been sexually abused, those are just heart-wrenching cases. How would I manage that? I think I would manage it by a determination. It would be my duty to listen and to render a judgment according to the law, to hear the evidence, to hear out everybody, and to make the best judgment I could. I think it's helpful to say the lawyer's duty is to listen to the law, to listen to the lawyers, to listen to the witnesses, to listen to the parties, and do the best we can.
Thank you, Scott. And Ken.
Thank you. I think the extreme cases of abuse are difficult to hear. Sadly, I've heard very extreme cases of abuse, and again, as I said earlier, I wouldn't share those with you. But you hear those, and it's unfortunate. The more you hear them, the more you can tolerate. Not necessarily tolerate the action, but at least personally you can bear up under hearing these sorts of things and still discharge your duty. And that I think I know I could certainly do. I think really, as I alluded to earlier, the harder cases are going to be cases that are narrowly decided. Cases of dependency, where the reason why I'm hearing and wondering whether this child should go home to his or her mom or dad is because of substance abuse. I mean, methamphetamines is horrendous. We hear it all the time in juvenile court, in children's services cases, over and over and over again. And you see glimmers of hopes. You want to cheer for the parent. You do. You want them to get well. You want this, because the child deserves to be with their parent if they can. They deserve to have a healthy, well-adjusted parent. You want to see that happen. It's going to be hard to know for certain. I think you just have the best information you can. You make sure you have CASAs involved. You have therapists involved. You order assessments. You have to get as much information as you can to know whether this borderline case is one in which the child goes home or doesn't.
Thank you. And that concludes the question part of the forum. We're going to move to closing statements. As a reminder, each candidate will get 2 minutes. And as luck would have it, they're sitting in the order that they will go, starting with Scott, then to Ken, then to Zach, and to Rusty. And please hold your applause till the very end.
So I've been practicing law for 30 years, and that's amazing. It doesn't seem like it could possibly be 30 years. That's been in the area of probate and real property, business, juvenile court, and custody cases. I've done over 500 or nearly 500 misdemeanor prosecution cases for the Village of Albany over that time. I'm a 57-year resident of Athens County. It's pretty amazing. And except for the 6 years I spent in school in Virginia and 1 year at the U.S. Court of Federal Claims adjudicating vaccine injury cases involving children. I was an OU history grad, 1984. One of my favorite activities, probably my favorite activity, is as treasurer of the Athens Foundation Board. I get to sign all the grant checks, and to all those deserving grantees out there. I'd like to just end with this, an encouragement to me and to my colleagues here and to you, that the role of the judge really is to listen to the law, to listen to lawyers, to listen to the parties and witnesses, to draw conclusions with modesty according to the law. And listening is hard work. It requires breadth and experience. It requires skills built over the course of that experience. It requires faithfully following the law as the law itself aims for justice. It requires a discipline of the lawyer who is a judge to remove personal thoughts, personal feelings, personal beliefs in order to be disciplinedly faithful to carry out the judgment that the law would render. And that's the hope. So I'd just like to encourage my colleagues as well as myself that that's a great mission.
Thank you, Scott. Ken?
Thank you. I just want to close just by explaining why I'm running. I'm running because my mission of service to my community has given me the necessary experience and ability to make me particularly suited for this position. I knew always back in high school that I was going to pursue a career of service, first as a teacher, and then by becoming an attorney, I was able to expand that opportunity to serve by representing children, the mentally ill, elderly members of our community, those who are most vulnerable. I've been able to serve on the governing board of several charitable organizations, civic organizations, and governmental bodies. And what I have found is that by remaining dedicated to this path of service, I now see myself with the proper experience, abilities, and disposition that makes me well suited for judgeship, particularly in juvenile and probate judge, as a probate and juvenile judge. I believe I can fully realize my mission and take my experience and abilities and put them to their greatest use in this position. My personal and professional experience has prepared me for this role and allows me to be of great benefit, I believe, to those who would appear before me in court. This is a situation where I found myself by pursuing that mission of service, and I can't ignore this opportunity now. I've never imagined when I began as a teacher and wanting to serve that I would end up with this opportunity in front of me. But now that I find myself in this situation, I feel compelled to answer this call of service. I know for certain that I would make an excellent probate and juvenile judge. I just hope you would give me that chance.
Thank you. Zach.
Thank you. I think you guys have heard me enough to know that I'm a true public servant at heart. And I think you've also understood that I'm passionate about what I do. It takes a special person to be a juvenile probate judge. It's not an ordinary judgeship. I think the people sitting up here will agree with me. I'm going to hold juveniles accountable. But also the main thing that I want to be able to do, and I think I can do, is I can relate to them. I can show them compassion, and I can provide them an avenue to succeed. That's the big key word here, is succeed. The role of the juvenile court is obviously to rehabilitate the offender. I will find ways to make sure that that will happen. I'm going to work with schools to make sure that the truancy numbers are lowered. I'm going to work with mental health of the juveniles to make sure that we can break that disconnect of individuals essentially graduating from juvenile court to adult court, where I have seen them countless times. You also heard me tell you that I believe that the juvenile probate court percentage-wise is up to 70 to 75% is involving juvenile court matters. You also heard that I'm the only person up here that has experience as both a prosecutor and also a criminal defense attorney for juveniles. A lot of these, again, I want to break that trend. For probate matters, I want to make sure that I'm providing closure to families. I'm going to not waste no time in issuing decisions. I will be firm, fair, and passionate to all litigants regardless of status. And I hope that you'll understand that I'm going to be the best candidate for this job simply because this is something I want to do. I care about our community. I care about our kids. I appreciate the Athens County League of Women Voters for putting on this forum. I appreciate my colleagues for being here. I will stick around after, as people who know me. I am an open book. Ask me any question you want, and thank you very much for coming to this forum.
Thank you, Zach.
Well, we've been in here for an hour and a half, so thank you for everyone who stuck with us during that time. We've heard a lot of opinions, and we come from a lot of varied backgrounds, but one thing that I think we've all expressed tonight is that we felt that Judge Stewart had done a great job over the last decade or so. There's a lot of reasons that Judge Stewart did a great job, but I think one of the main reasons was he came into the job with prior judicial experience. He was a magistrate before he became a judge. That is the one aspect I bring to the table that separates me from the other candidates. I have 4 years of judicial experience as acting judge of the Athens Municipal Court. Think in your own career how long it took you to become efficient and good at what you do. As hard as you work, as bad as you want it, you need experience. If you don't have the experience, you're not going to do as great of a job as someone else. When you're in court, it may be on the most important day of your life, and you deserve to have the best qualified individual hearing your case, and I believe I'm that person. Thank you.